The GDPR enforcement debate is framed as if we have only two choices. Either we defend collective redress without qualification, or we treat it as a litigation problem to be contained. That is the wrong frame. Collective redress is not the problem. In many cases, it's the only realistic way to make dispersed data protection harms visible. The problem is what happens when collective redress meets a fragmented enforcement architecture, uncertain compensation doctrine, parallel institutional tracks, and a new layer of procedural scale. This lecture is about that shift. It's about the move from individual rights to industrial litigation, and about how we keep access to justice, legal certainty, and coherent enforcement in the same system. Hello, and welcome. I'm Dr. Mark Leiser. I work on technology law, sometimes data protection, sometimes digital governance, deceptive design, platform regulation, and the institutional problems that emerge when legal systems try to govern at scale. This lecture is based on a SIPL report that I did on collective redress and GDPR enforcement. The title is deliberately direct, From Individual Rights to Industrial Litigation, the Transformation of GDPR Enforcement. The phrase industrial litigation is not meant as a cheap criticism. It is a description of a change in enforcement conditions. GDPR rights were built around individuals. A data subject, a controller, a complaint, a request, a remedy. That model remains central, but the world in which it operates has changed. Data processing is now infrastructural. Harms are often diffuse, probabilistic, and systemic. Public enforcement is actually stretched. Cross-border cases can move very slowly. Representative litigation is becoming more professionalized, and technology now lowers the marginal cost of finding, drafting, and coordinating claims. So the question is no longer simply whether the GDPR gives individual rights. Of course it does. The more difficult question is whether the enforcement architecture can preserve a meaningful relationship between harms, procedure, and remedy when those rights are exercised at scale. That is the thread running through this lecture. I'm not arguing against collective redress. I'm arguing for calibration. Collective redress should remain a strong and legitimate part of EU data protection enforcement. But its legitimacy in the next phase depends on institutional design. It depends on whether the system can distinguish between unresolved systemic harm and procedural repetition, between genuine rights vindication and leverage, between the necessary aggregation and scale detached from demonstrable injury. The more mature question is not, should collective redress exist? It should. But the mature question is, how do we keep it tethered to its justificatory foundations? One further point at the outset. This is not a beginner's introduction to collective redress. I'm assuming familiarity with the GDPR, Article 80, Article 82, and the basic public-private enforcement split. The purpose here is to put those familiar pieces into a different frame. I want to treat collective redress not as an isolated procedural topic, but a stress test for the whole GDPR enforcement system. The core thesis I have is simple. The enforcement equilibrium has shifted. Collective redress now sits at the intersection of three forces. First, institutional bifurcation. GDPR enforcement runs through a public supervisory track and private, judicial, or representative track. These tracks are connected in law, but only loosely coordinated in practice. They move on different timelines, use different evidentiary logics, and produce different kinds of signals. Second, Article 82 uncertainty. Compensation doctrine is just not remedial. It shapes behavior before litigation begins. It affects pleading strategy, forum selection, settlement pressure, and the economics of aggregation. Third, scalable initiation. it is becoming easier to identify potential infringements, template complaints, coordinate claimants, and move between procedural tracks. In some ways that can be good. It can support access to justice, but it also changes incentives. The result is a new enforcement environment. Complaint volumes rise, cross-border matters slow, harm thresholds diverge, automation lowers cost, finality weakens. So I want to be precise about my claim. I'm not saying that more litigation is bad. I'm not saying that collective action is suspect. In data protection, individual enforcement is often unrealistic. A single person rarely has the information, resources, or incentives to challenge a systemic processing practice. Collective redress can solve rational disinterest. It can reveal patterns that a one-off complaint cannot capture. It can complement public enforcement where supervisory authorities are slow, constrained, or unable to award compensation. But structural strengths can produce structural risks. When public and private enforcement are weakly aligned, when national procedures diverge, when compensation thresholds remain uneven, and when claim initiation becomes cheaper, litigation pressure can start to separate from demonstrable individual injury. That separation is the central risk, not because it helps defendants, and not because it irritates controllers, but because enforcement legitimacy depends on the coupling between the thing suffered, the procedure used, and the remedy sought. If that coupling remains strong, collective redress strengthens the system. If it weakens, we get uncertainty, duplication, and a sense that disputes never quite end. For a specialist audience, the important move is to avoid treating these forces separately. Bifurcation, Article 82 uncertainty, and scalable initiation are not three independent problems. They interact. A fragmented procedure is manageable when claims are rare. Doctrinal uncertainty is manageable when cases are individualized. Automation is manageable when the system has strong filters. The difficulty arises when all three conditions arrive together. The GDPR is often spoken about as it has one enforcement system. It does not. It has a layered architecture of enforcement. On the public side, a complaint or notification may lead to supervisory authority investigation. In cross-border cases, the one-stop shop adds cooperation and consistency mechanisms. The output is administrative decisions, corrective powers, sanctions, and compliance signals. On the private side, we have mandated bodies, representative actions, national courts, admissibility rules, civil remedies, declarations, injunctions, and damages. The output is judicial, compensation signals, precedent, and sometimes settlement pressure. Both tracks are legitimate. Both are part of the design. The difficulty is that they are only loosely coupled. There is no default sequencing rule. There is no automatic information flow. There is no harmonized admissibility filter. There is no shared harm threshold. A single processing practice can be investigated in a supervisory authority while being challenged at the same time in court. A DPA may focus on systemic compliance and proportional sanctioning. A court may focus on individualized harm, causation, and evidentiary sufficiency. Those are not the same questions. This is not inherently wrong. Regulatory pluralism is not a defect. In many cases, public and private enforcement coexist. Competition law is the obvious comparison. Public infringement decisions and private follow-up, damages, actions can reinforce one another. But coexistence requires alignment. It requires some architecture for sequencing, evidentiary weight, and institutional communication. In GDPR enforcement, that architecture remains underdeveloped. So the issue is not institutional conflict. The issue is institutional drift. If the same factual constellation can produce different signals in different fora, and if those signals do not meaningfully speak to one another, regulated actors struggle to understand what compliance requires. Data subjects may receive uneven outcomes depending on where and how a claim is brought. Courts and authorities may spend scarce resources addressing overlapping disputes. Collective redress enters precisely here. It can reinforce public enforcement by adding capacity and compensation, but if the tracks are not aligned, it can also magnify the coordination gap. The public-private distinction therefore matters because it shows why the problem is institutional before it is motivational. We do not need to assume bad faith by any actor. The structure itself creates multiple pathways, different incentives, and opportunities for repeated escalation. This is why I use the language of signals. A DPA decision is not merely a decision in one file. It becomes a compliance signal. A court ruling on harm is not merely a private dispute. It becomes a signal about the value of claims, the viability of aggregation, and the cost of contesting similar conduct. If the signal points in different directions, actors will not simply comply with the law in the abstract, they will manage institutional risk. Why is this becoming more visible now? Because the environment's changed. The original enforcement model assumed something relatively contained: identifiable infringements, articulate harm, administrative investigation, a reviewable decision, and compensation where appropriate. Modern data ecosystems do not always behave like that. Processing is continuous, it's infrastructural, it's mediated by platforms, cloud architectures, advertising systems, recommender systems, and increasingly AI. Risk is not always episodic. It's often embedded. A data subject may know that a practice exists. They may not know which entity is responsible. They may not know what inference has been drawn, or what transfer has occurred, or what profile has been generated, or how a system has affected them. In that setting, an individual complaint mechanism is important but incomplete. This is where collective redress has real value. It can translate diffuse, low visibility effects into a procedural form that institutions can address. It can aggregate small harms. It can respond to information asymmetry. It can provide compensation where the administrative enforcement cannot. But the same conditions that justify collective redress can make calibration harder. If the harm is systemic but hard to articulate, how do we distinguish real injury from abstract dissatisfaction? If processing affects millions, how do we prevent scale from substituting for proof? If a claim is framed as group-wide, how do we ensure that the group is real, the common issues are genuine, and the remedy corresponds to an addressable problem? These are not anti-rights questions, they're rights-preserving questions. A system that cannot explain why one scaled claim is legitimate and another is not will eventually lose credibility with everyone: the courts, regulators, firms, and the public. So the mismatch is this: harm production has become infrastructural, but enforcement remains largely complaint-driven and case-centered. Collective redress expands in that gap. It's both a solution to the gap and a source of pressure within it. This is why the next phase of GDPR enforcement is not simply more enforcement. It's more enforcement under conditions of scale, fragmentation, and uncertainty. This also explains why familiar categories sometimes feel strained. We ask whether a person has suffered harm, but the effect may be distributed across a population. We ask whether a controller has infringed a duty, but the practice may involve multiple actors and technical intermediaries. We ask for proof, but the evidence may sit inside systems that data subjects can inspect. Collective redress is attractive precisely because it gives procedural form to those distributed effects. The next point is that collective redress in Europe is not one thing. It's a procedural spectrum. Article 80 of the GDPR provides a basis for representative standing. The Representative Actions Directive adds a consumer collective action layer. But neither of those instruments creates a single fully harmonized GDPR damages regime across the Union. Instead, we get layers: GDPR representative standing, national civil procedure, consumer collective action regimes, sector-specific procedural adaptations. The practical shape of collective redress depends on how those layers interact in each member state. That means procedural ecology matters. At one end, we find more restrictive systems, opt-in designs, an injunctive focus, funding restrictions, tighter same interest rules, and more limited damages orientation. Ireland is a useful illustrative reference here because it does not provide the same kind of general damages-oriented collective redress environment that we see in more permissive systems, and third-party funding remains constrained. In the middle, we find hybrid systems. Here, collective routes exist, but they're procedurally demanding. Like cost exposure, admissibility, certification, funding, and evidentiary standards all matter. At the same end, we find more permissive regimes, opt-out design, flexible standing, funding availability, and scalable aggregation. The Netherlands is the usual example because its architecture has made it one of the most attractive European fora for collective activity. But even here, we need to be careful. Permissiveness does not mean a free-for-all. Dutch courts have shown active sensitivity to representativity, commonality, manageability, and the need for real affected constituency. That is important. It shows that aggregation-friendly systems can still police the boundary between collective adjudication and abstract mass harm. The larger point is this: forum selection is not a moral failing. It's a rational response to the procedural diversity of the European Union. If some jurisdictions make aggregation easier, funding more available, and harm treatment more predictable, collective claims will not distribute evenly. They're going to cluster in that jurisdiction. That clustering is not unique to data protection. It's also a feature of collective litigation systems. But in the GDPR sense, it matters because the substantive rights are harmonized while the procedural pathways are not. The same union right can therefore generate very different litigation dynamics depending on national procedural ecology. That is why any serious discussion of collective redress has to move beyond kind of abstract apport or opposition. We need to ask how the procedural design itself shapes enforcement behavior. The phrase national procedural ecology matters because no single feature determines the outcome. Opt-out design matters, but not alone. Funding matters, but not alone. Admissibility matters, but not alone. Judicial culture, disclosure, cost rules, settlement architecture, claimant organization, and court capacity all matter. The ecology is the combination of these factors. That is why transplanting one mechanism from one member state to another rarely produces the same result. In practice, collective GDPR cases tend to cluster around a relatively stable set of issues. The first is systemic processing practice, real-time bidding, ad tech ecosystems, large-scale behavioral advertising, platform data architectures. These are practices that affect large populations through standardized systems. The second is these match breach incidents that we all know of, cyber incidents or security failures that affect millions of people or many individuals at once. The third is transfer and international processing, cloud architectures, cross-border flows, compliance with transfer rules. The remedial menu is also relatively familiar. Injunctions requiring cessation, modification, or redesign, declarations of unlawfulness, and increasingly Article 82 compensation for material and non-material damage. Compensation is the pivot. An injunction changes behavior. A declaration clarifies legality, but compensation changes the economics of aggregation. Even a modest per person sum becomes significant when applied across a large claimant population. That does not make compensation illegitimate. Article 82 is there for a reason. Where people have suffered damage because of an infringement, compensation matters. But compensation also changes and shapes ex ante strategy. It affects which jurisdiction looks attractive. It affects whether a claim is economically viable. It affects settlement pressure. It affects how representative bodies plead non-material harm. That is why Article 82 cannot be treated as a narrow doctrinal sidebar. It's a structural variable in the enforcement system. Again, the argument is not that compensation claims are suspect. The argument is that compensation doctrine interacts with procedural architecture. A relatively open harm standard combined with opt-out aggregation and funding availability produces different incentives from a narrower harm standard combined with opt-in design and funding restrictions. For policymakers and courts, the question is not simply whether compensation should be available. It should be. The question is how to ensure that compensation route remains anchored to actual harm, evidential sufficiency, and proportionality when claims are scaled up. There's also a sequencing difference between remedies. Injunctions often look forward. Stop this, change that, redesign the process. Declarations clarify the legality. Compensation looks backwards, but changes forward incentives because it attaches monetary consequences to a category of harm. Once compensation is scaled, the remedial question becomes an economic question as well as a legal one. Article 82 is the structural stress point because it sits where rights, incentives, and procedure meet. The CGAU has made clear that infringement alone is not enough. There must be damage, and there must be a causal link between the infringement and the damage. But that still leaves difficult questions. What counts as non-material damage? Does loss of control suffice? When does fear of misuse qualify? What evidentiary threshold applies? Where's the line between a non-trivial interference and a claim that should not attract compensation? These questions matter doctrinally, but they also matter institutionally. A high threshold jurisdiction and a low threshold jurisdiction do not simply produce different legal outcomes. They produce different incentive environments. Where the evidentiary burden is significant, aggregation is less attractive and settlement pressure is lower. Where non-material damage is recognized more broadly and the evidentiary burden is more claimant-friendly, aggregation becomes more attractive and settlement pressure increases. Litigation concentration risk rises. This is not an argument that high thresholds are always better. A threshold that is too strict that can make rights ineffective. It can leave systemic harm uncompensated. It can undercut deterrence. But a threshold that is too low can detach compensation from demonstrable injury and allow procedural skill to do the work that evidence should do. The point is balance. Article 82 should compensate real harm, but it should not become a mechanism through which the mere existence of a large effective population substitutes for proof of damage. This is where recent case law becomes important. Nacional Agencia shows that fear of misuse may be relevant, but it must be sufficiently substantiated and well-founded in the circumstances. Brillen-Rottler adds a different but related point. Data subject rights are fundamental, but their exercise is not immune from abuse analysis where a request is used artificially to generate compensation leverage. Those cases do not solve the Article 82 problem, but they show that courts are increasingly aware of the need to preserve the line between rights vindication and procedural instrumentalization. For collective redress, that line is crucial. If Article 82 remains uneven across member states, forum selection will remain rational. If forum selection remains rational, claims will cluster. And if claims cluster in systems with both procedural permissiveness and broad harm recognition, the union will continue to experience enforcement intensity unevenly. The difficult point for courts is that non-material harm is real, but also easy to overstate. Distress, anxiety, loss of control, uncertainty, and fear of misuse are not imaginary. They're part of the experience of data protection harm. But the law still needs evidence, causation, and proportion. Otherwise, the concept of non-material damage risks becoming a placeholder for infringement itself, which is exactly the distinction Article 82 cannot lose. Fragmentation makes forum selection rational. That sentence is worth pausing on because it strips away a lot of the unhelpful moral language. In a fragmented system, sophisticated actors respond to incentives. Representative bodies, claimants, funders, defendants, and advisors all read the procedural map. If a jurisdiction offers opt-out routes, flexible standing, manageable admissibility filters, funding availability, predictable judicial treatment of non-material harm, and lower friction at scale, it will attract collective activity. That's not surprising. It's exactly what one would expect. The Netherlands illustrates the point. It has features that make collective litigation more legible and scalable. It is therefore attractive. But the Dutch example also shows the other side. Courts in permissive systems must become more disciplined about representativity, commonality, manageability. If they do not, aggregation can drift from concrete group interest into abstract mass claims. The lesson is not that permissive systems are bad. The lesson is that permissive systems need strong filters. The more powerful the aggregation tool, the more important the admissibility discipline. For GDPR enforcement, this matters because the Union is dealing with harmonized substantive rights, but non-harmonized procedural machinery. So the practical experience of Article 82 will vary. The economic viability of collective redress will vary. The settlement leverage attached to similar claims will vary. That variation has consequences for legal certainty. Companies operating across member states do not simply ask, what does the GDPR require? They ask, where might this be litigated and under what procedural rules, with what evidentiary assumptions, and at what scale? Individuals and representative bodies ask a parallel question from the other side. This is why collective redress cannot be evaluated in isolation from national procedure. The legal right and the procedural container operate together. Change the container and you change the practical meaning of the right. This is why the language of forum shopping can be misleading. It implies opportunism. In reality, forum selection is a predictable feature of legal systems with uneven procedural design. If the Union creates a right but leaves the enforcement container to national systems, actors will compare containers. The better question is not whether actors choose fora strategically. Of course they will. The better question is whether the resulting pattern is acceptable for a supposedly coherent enforcement system. Fragmentation also multiplies escalation pathways. Imagine the sequence on the slide. First, an individual complaint or rights request. Second, an administrative or judicial outcome. Third, the issue is reframed as systemic or group-wide. Fourth, a representative action or scaled damages claims follows. That sequence is not inherently improper. In many cases, it's exactly how unresolved systemic harm becomes visible. An individual complaint may reveal a broader problem. A slow administrative process may fail to provide compensation. A representative action may be the only realistic way to address a practice affecting thousands or millions of people. So I want to be very clear, escalation can be legitimate, necessary, and rights protective. The structural risk arises when materially similar conduct is repeatedly reframed across fora without new grounds, without meaningful coordination, and without a clear relationship between prior determinations and subsequent collective claims. From the perspective of regulated entities, exposure can then feel procedurally regenerative. Even if one forum produces a favorable outcome, the issue can reappear through another pathway, at another scale, under another evidentiary logic. That does not mean the later proceeding is unlawful. It may be entirely lawful. The question is whether the system has had enough tools to distinguish between generally unresolved harm and repeated procedural reframing of issues that have substantially been addressed. This is not a question of motive. It's a question of architecture. If the system permits multiple escalation routes, actors will use them. If administrative delay creates incentives to go elsewhere, actors will go elsewhere. If Article 82 is uncertain, actors will test it. If claim initiation becomes cheaper, more claims will be initiated. The responsibility for coherence lies with system design. We should not build an enforcement architecture that depends on actors declining to use lawful pathways that the system itself has made available. The real task is to design pathways that preserve access to justice while preventing scale from becoming a way to neutralize finality. There is a parallel here with my broader work on digital governance. Legal uncertainty does not stay confined to doctrine. It travels into product design, risk management, litigation strategy, insurance, funding, and institutional behavior. Once uncertainty becomes part of the operating environment, repeat players learn how to use it. That is why doctrinal clarity is not a technocratic luxury. It's part of the rule of law. This brings us to the coordination gap. The GDPR preserved public and private remedies. It did not create a hierarchy between supervisory authorities and courts. That was a legitimate legislative choice. The problem is that it did not build enough alignment mechanisms for the world we now inhabit. At present, there's no mandatory stay of collective proceedings pending a DPA outcome. There is no automatic evidentiary deference between courts and supervisory authorities. There's no structured harmonization of harm thresholds. There's no private cross-border consistency mechanism for damages claims. The result is duplication, divergence, inefficiency, and uncertainty. Duplication arises when the same conduct is investigated and litigated in parallel. Divergence arises when courts and DPAs send different compliance signals. Inefficiency arises when actors spend resources managing overlapping tracks. Uncertainty arises because finality weakens when exposure can be repeatedly reframed. Now, coherence does not require hierarchy. I'm not suggesting that courts should be subordinated to supervisory authorities or that representative standing should be curtailed. Courts have their own constitutional role. Private enforcement has its own legitimacy. Data subjects shouldn't be forced to wait indefinitely for administrative processes that may be slow, partial, or non-compensatory. But coherence does require procedure. In complex regulatory systems, alignment rarely appears by accident. It's built through sequencing rules, evidentiary doctrines, information flows, and admissibility filters. The coordination gap is therefore not a technical inconvenience, it's a rule of law issue. Legal certainty depends on actors being able to understand the legal consequences of conduct. Access to justice depends on claims being heard through workable procedures. Both values suffer if the system cannot explain how public and private enforcement relate to one another. The point is not to make enforcement weaker. The point is to make it intelligible. One practical challenge is that public and private tracks ask different questions even when they examine the same conduct. A supervisory authority may be concerned with compliance architecture, proportionality, deterrence, and the public interest. A court may be concerned with standing, causation, proof of damage, limitation, and remedy. Those are legitimate differences. And without a procedural bridge, legitimate differences can become incoherent signals. Courts are beginning to police the boundary. The signals are not uniform, and they're not a complete solution, but they are important. First, Article 82 compensation requires more than infringement alone. Harm must be real and provable. That is a basic but essential discipline. Second, fear of misuse can qualify as non-material damage, but not as a purely speculative assertion. It must be grounded in the circumstances. That's the significance of the Nationale Agencia line. Third, Brillen-Rottler is a notable abuse of rights signal. The courts accepted that even a first access request can, in exceptional circumstances, be excessive or abusive, where it's made not to understand processing or verify lawlessness, but to artificially create the conditions for compensation. At the same time, that is not a license for controllers to reject inconvenient requests. The threshold is high, contextual, and evidence-based. Fourth, admissibility discipline in collective proceeding matters. Representativity, commonality, manageability are not procedural niceties. They are the filters that keep collective litigation anchored to a real affected group and a real dispute. Taken together, these signals do not delegitimize collective redress. They do the opposite. They help preserve the legitimacy by clarifying that scale must remain connected to some sort of substance. Legal systems that allow collective redress cannot filter weak, abstract, or leverage-driven claims will eventually provoke backlash. A legal system that filters too aggressively will deny access to a justice for diffuse harms. The task is to hold the line between those errors. This is why I prefer the language of calibration. Calibration is not a euphemism for retrenchment. It's the discipline that makes robust rights sustainable. The judicial boundary work is therefore doing two things at once. It protects data subject rights by keeping the compensation route open when the harm is real, and it protects the system from inflationary use of those rights where the procedural form is detached from the purpose of the right. That dual function is easy to miss if we insist on turning every judgment into a victory for one side or the other. The next structural variable is automation. AI does not change the substance of GDPR rights. It changes the economics of initiating claims. Before, enforcement was friction-filled. Identifying issues required manual review. Drafting required legal expertise. Coordinating claimants required time, infrastructure, money. Each additional claim increases effort. And after AI-assisted initiation, the marginal cost curve changes. Pattern detection across policies, notices, logs, and repeated practices becomes easier. Drafting can be templated. Complaint assembly can be structured. Claimant communication can scale. Cross-border coordination can become more efficient. That's not inherently bad. It may be a major access to justice gain, but data subjects who lack resources can benefit from tools that surface problems and help them exercise their rights. Representative bodies can use technology to identify systemic practices that would otherwise remain invisible. But automation also creates scale asymmetry. Procedural volume can rise faster than institutional capacity to assess it. A flood of formally valid but evidentially variable claims can put pressure on courts, supervisory authorities, defendants. The risk is not volume itself. The risk is volume decoupled from harm calibration. This is the distinction between assistance and manufacture. Assistance helps people vindicate real rights. Manufacture uses procedural triggers to generate leverage-independent or demonstrated injury. That distinction is not always easy to draw. It requires context, evidence, careful institutional judgment, but it will become more important as claim initiation gets cheaper. The law can't simply say less enforcement in response to automation. That would be wrong. But it also cannot assume that more procedural volume always equals better rights protection. Sometimes it does. Sometimes it simply shifts pressure into a system without improving substantive justice. Filtering, therefore, becomes decisive. Harm, admissibility, abuse of rights, representativity, commonality, and proportionality all become more important as scale increases. The question is not whether technology should facilitate enforcement. It should. The question is whether the enforcement architecture distinguishes facilitation from amplification. This point will matter even more as legal technology becomes normal rather than exceptional. We should assume that claim identification, claimant intake, translation, document generation, and cross-border coordination will become cheaper. That's not a future scenario, it's the direction of travel. The enforcement system therefore needs to be robust to cheap initiation. It cannot rely on cost and friction to do the filtering work that legal standards should do. The rule of law question is coupling. The real tension is not collective redress versus corporate interests. That framing is just too crude. The real tension is robust access to justice versus stable, coherent enforcement. Both are rule of law values. On one side, access to justice. Aggregation is essential where individual harms are diffuse, information asymmetry is severe, and standalone litigation is irrational. Without collective mechanisms, many systemic practices will never be challenged effectively. On the other side, legal certainty and finality. Decisions must mean something. Compliance conclusions must stabilize expectations. Legal risk must be intelligible. A system in which materially similar disputes can be endlessly reframed at scale risks becoming perpetually contestable. The answer is not to sacrifice one value to the other. The answer is to maintain strong coupling between three elements. First, substantive harm, actual injury, evidentiary sufficiency, non-triviality. Second, a procedural pathway, complaint, judicial claim, representative action, sequencing. Third, remedial outcome, like an injunction, declaration, compensation, deterrent signal. When those elements are aligned, collective redress is legitimate and powerful. It makes rights real. It corrects systemic harm. It complements public enforcement. When those elements drift apart, the enforcement begins to lose coherence. Form selection becomes the dominant strategy. Repeated reframing weakens finality. Inconsistent findings complicate compliance. Settlement pressure may reflect procedural scale rather than the gravity of the underlying violation. Finality does not require identical outcomes across institutions. Courts and DPAs can reach different conclusions for good reasons, but finality does require that legal determinations meaningfully reduce uncertainty. If nothing ever settles the risk, law stops guiding conduct and becomes permanent exposure management. That's bad for businesses, it's bad for regulated entities, but it's also bad for rights. Rights are not protected by endless uncertainty. They are protected by institutions that can apply legal standards responsibly. This is also where proportionality returns to the center of the discussion. Proportionality is sometimes treated as a concession to regulated entities. That's a mistake. Proportionality is the discipline that connects rights to institutional reality. It asks whether the response fits the likelihood and seriousness of the harm, the evidentiary position, the procedural route, and the remedy sought. Without proportionality, enforcement can be intense and still not be coherent. So what should calibration look like? First, clarify Article 82. We need greater substantive clarity on compensable non-material harm and evidentiary sufficiency. Not to make compensation impossible, but to make it principled. Second, improve coordination between courts and supervisory authorities. That may involve better information flows, clearer treatment of administrative filings, and procedural mechanisms for overlapping proceedings. Third, tighten procedural robustness in representative actions. Standing, funding transparency, representativity, commonality, and admissibility should not be treated as obstacles to justice. They are the conditions that make collective justice credible. Fourth, address sequencing and prior determinations. Where materially identical factual and legal issues have already been considered, subsequent collective proceedings should have to engage with that history. Not because later claims are forbidden, but because the system should distinguish unresolved systemic harm from procedural re-litigation. Fifth, guard against industrialization. That means safeguards against purely volume-based filing dynamics where scale becomes a substitute for evidence or proportionality. What calibration is not a case against collective redress. It's not a defense of under-enforcement. It's not a hierarchy that subordinates courts to DPAs. It's not a procedural shield for bad data practices. What calibration is, a way to preserve access to justice while improving predictability, finality, and the coupling between harm, procedure, and a remedy. This is a systemic exercise, not a behavioral accusation. We do not need to speculate about anyone's motives. If design features predictably generate escalation, then the responsibility for restoring coherence lies with the architecture itself. That, in my view, is the next phase of GDPR collective redress. The calibration levers are not exotic. They are the ordinary tools of mature procedural systems. Clarity, coordination, admissibility, sequencing, safeguards. What is difficult is political and institutional will. It's easier to describe simplification as deregulation or to describe any procedural filter as hostility to rights. But a system can be rights protective and still insist on disciplined concepts. So let me close with 5 propositions. First, collective redress is now a core component of GDPR enforcement. It's not a peripheral procedural add-on. Second, the central institutional factor is bifurcation. Public and private enforcement run in parallel with too little structured alignment. Third, Article 82 is not just remedial doctrine. It's an incentive variable that shapes forum choice, pleading strategy, settlement pressure, aggregation viability. Fourth, automation and natural procedural divergence can industrialize claims initiation faster than institutions can calibrate it. Fifth, the policy task is calibration. Preserve access to justice while restoring strong coupling between harm, procedure, and remedy. The future of collective redress and data protection law will not be determined by whether it exists. It exists, and it should. It will be determined by the institutional choices that govern how it operates. So the bottom line is this. Collective redress should remain a strong part of the EU data protection framework, but its legitimacy in the next phase depends on preventing procedural scale from drifting away from demonstrable harm. Rights need realism, law needs discipline, and enforcement, if it's to remain legitimate, needs calibration. For the live CIPL discussion, I want to just now open the conversation to questions. I'd love to hear from you, not just about Article 82, but institutional questions. Who should build the coordination bridge? What should count as sufficient harm at scale? How should prior determination be treated? And where should the line be drawn between access to justice technology and leverage-driven automation? My name is Dr. Mark Leiser, and I hope you enjoyed this lecture. Keep coming back for more insights into law, regulation, and digital technologies.